Thank you for joining us. I'm Kalina Eck.
And I'm Carrie Chilton. We're staff attorneys with the Disability Law Center of Virginia, and we'd like to tell you a little bit about discipline. What protections and procedures are in place for students with disabilities?
Let's start with the basics. There are 3 levels of discipline, broadly speaking. In-school discipline, that's things like detention, staying in at recess or lunch, moving a clip on a color chart, that sort of thing. Then there's short-term removal from school, or suspensions for 10 days or fewer, and long-term removal, longer than 10 days, and expulsion. And that 11th day marker is important because it creates what is called a change in placement. Schools, through the IEP team, have to take steps to prevent behaviors before they occur, or to lessen the likelihood of those behaviors once they show up. They can do this through goals and services in the IEP, or can conduct a functional behavioral assessment, FBA, to develop a behavior intervention plan, BIP, which we'll talk about in more detail in just a few slides.
There are several important differences between short-term and long-term removal. Short-term removal is 10 school days or less. Students with disabilities who are facing a short-term removal receive the same discipline as students without disabilities. The school is not required to provide them with any educational services during this time. Long-term removal is more than 10 school days. This can either be consecutive or based on a pattern. An example of a consecutive long-term removal would be a suspension of 15 days. Multiple short-term removals in the same school year can be added together to constitute a long-term removal if there is a similar pattern of behavior in each incident. For example, if a child is suspended from school for 3 days, 4 different times in the same school year, for hitting other students, these suspensions could be added together and count as a long-term removal. When a child receives a long-term removal, this triggers the requirement that a school hold what's called a manifestation determination review.
A manifestation determination review, or an MDR, is required before any disciplinary action that creates a change in placement. That's why that 11th day is so important. It triggers the MDR process. So no later than 10 days after the school decides that long-term removal is the right call, they have to hold the meeting, which makes sense, right? You don't want the student to be out of school more than 10 days before you decide if they should be getting some protections against that removal. So who gets to make this decision? The MDR team looks a lot like the IEP team: parent, representative from the school division, and relevant members of the IEP team. Together, they review all the relevant information in the student's file and any additional information provided by the parent. And the whole exercise is to see if there's a relationship between the child's disability and their behavior. Basically, based on what the school already knows about the student, should they have seen this coming and taken steps to make sure it didn't happen?
The MDR team will look at 2 different standards to determine if a child's behavior is a manifestation of their disability. The first standard is whether the conduct is caused by or has a direct substantial relationship to a child's disability. This is a whole picture approach. The team will look at things such as the child's discipline history, environmental factors, the type of misconduct, and the child's disability to determine how related the disability and behavior are.
The second way a student's behavior can be a manifestation of their disability for the MDR purposes is if the conduct in question is a direct result of the school failing to implement the IEP. Basically, if the school didn't follow the IEP and that failure led directly to the behavior, something the school definitely knew about and didn't follow the steps agreed to prevent it. The factors MDR teams look at here are how the IEP section relates to the student's behavior and how the school's failure to provide accommodations or otherwise act the way they agreed to led to this entirely predictable behavior. This connection needs to be extremely direct for the MDR team to find a behavior or manifestation on this standard. It's not enough to say, for example, that the student didn't get large print materials in English on Friday and then vandalized the school with friends on the weekend. But it would be more in instances of the student's IEP calls for check-ins with the counselor between periods, and if the counselor wasn't available, next period the student has a verbal outburst because they're overwhelmed. or the student's BIP wasn't being followed and the behavior the BIP was in place to prevent happened. It needs to be a very clear and direct connection.
What happens if one of these standards is met? If Standard 1 is met, the student must be returned to their original placement. So if a child was placed on homebound education or into an alternative school as part of the disciplinary action, they must be returned to the school placement they were in prior. The exception to this is when a school and parent agree to a change in placement. This may happen if the parent and the school both think that a change in placement may be appropriate, even though the behavior was related to a student's disability. If Standard 1 is met, the school must also conduct a functional behavioral assessment, or FBA, unless one has already been completed. Using the data collected from the FBA, the school must then create a BIP, or modify the BIP if one already exists. If Standard 2 is met, this means that the IEP was not being followed. The school must take immediate steps to ensure the IEP is followed in the future. This may include training staff on the contents of the IEP. If the IEP was not implemented because the strategies in it were not practical in the classroom setting, the IEP team may choose to change the IEP so that effective strategies are in place. If Standard 2 is met, the school must also take the steps that are required when Standard 1 is met.
When the MDR team decides neither standard is met, then the student is disciplined just like a student without a disability would be. During the suspension, the school still has to provide services, though, so that the student can continue to participate in the general education curriculum. They also must continue to receive the services and modifications in the student's IEP so that the student can progress towards their IEP goals. Finally, when appropriate, the school must complete an FBA and create or modify a BIP or BIP so that the behavior does not continue. This means that the student needs to receive home-based education and any other services such as speech and occupational therapy during a long-term removal. If you disagree with the MDR team's decision, there are two options for appeal: an expedited due process hearing or an internal appeal to the school division. We'll talk about the expedited due process hearing in the next few slides, but the internal review just involves writing a letter, which should include a list of the information the MDR team didn't consider that you think they should have. This internal appeal request is a little more collaborative an option than the due process option, but of course doesn't involve a neutral hearing officer's review and decision at the end.
Expedited due process is used for disagreements about whether a behavior is a manifestation of a student's disability, whether several short-term removals create a pattern of behavior, and any placement change that is a result of a disciplinary action. Parents may represent their children at an expedited due process hearing. However, the school will likely be represented by an attorney, and since the process can be complicated and deals with special education laws, we strongly recommend that parents seek representation as well. Parents always have the opportunity to use mediation to resolve these disagreements, an option which can be less time-consuming and less adversarial. The speedy snail is a pretty accurate picture for the expedited due process hearing. It is quicker than the standard due process timeline, but can still be quite lengthy. Let's go through this timeline now. Due process timelines are much like a choose-your-own-adventure book. Depending on how things develop, and if the school and parent choose to waive certain steps, the timeline will look different for each case. This is just to serve as a general overview of the process so that you have an understanding of how long it can take. So, once the request for expedited due process is filed, a resolution meeting is held within 7 calendar days. This is a last-ditch effort for the school and parent to try to come to a resolution informally. The parent and school can waive this meeting if they both agree in writing. Parties may choose to do this if, for example, they've already gone through mediation on the issue and do not think that additional discussions will be useful. The expedited due process hearing is then held within 20 school days of the request being filed, unless the matter is resolved in 15 calendar days. So, after filing the request, you will have a resolution meeting, and then a little more time to try to resolve things informally. If that does not work, then the hearing will occur 20 school days or less from filing that request. The hearing officer then must issue their decision 10 school days after the hearing. So in total, you can be looking at a process that is 30 school days long from filing to decision. The hearing officer's decision can then be appealed to state or federal court.
One of the most important tools schools use or should use as part of the school's affirmative duty to prevent behavior that's going to lead to disciplinary action are functional behavioral assessments, FBAs, and behavior intervention plans, BIPs or BIPs. When you're trying to figure out why someone's acting the way they are and want a plan that'll get them to do something else instead. We have some other material on our website about behavior and behavior plans, but we'll talk about them briefly here as well. So who should complete an FBA or BIP? Just like you probably wouldn't have a PE teacher conducting a reading assessment, functional behavioral assessments shouldn't be done by just anyone. Years ago, we had a case where the school principal, who had no background in behavior, was doing all the FBAs and BIPs for the school. As with all evaluations, they should be done by qualified personnel. Behavior analysts are now licensed in Virginia, so that would be my first choice. Lots of schools also use PBIS instead. You really want someone who knows what they're looking at doing these assessments. So there's a 10-step process that goes like this. First, verify the seriousness of the behavior. Is this a student who's just annoying the teacher? Is this a big deal? Maybe, maybe not something worth developing a plan for. But once we've determined that this is a big enough problem that it needs an intervention, we look to define the behavior we're targeting. Tapping a pen, speaking without being called on in class. The more specific, the better, though I will caution against going too far. I once had a client whose MDR team decided the behavior in question, saying a specific curse word, wasn't a manifestation because, while they had a BIP in place to deal with him shouting curse words, this was a new and different word than they had planned for, so define the behavior reasonably specifically. Then someone, ideally a behavior analyst, but it could be a teacher or parent or someone filling out an observation form the behavior analyst designed, collects information on the reasons for the behavior. This can be direct observation or a review of the discipline record, interviews with the student, parent, teachers. Then the behavior analyst gets to work analyzing the data collected, looking for patterns, develops a hypothesis, an educated guess about why that student is doing that behavior, and then verifies that hypothesis and creates a behavior intervention plan. These are the interventions we'll use, this is how we'll reduce or change the presentation of the trigger for the behavior if we can, that kind of thing. After the plan is made, you still need to evaluate the delivery of the BIP. Is this a plan everyone who needs to implement can implement? And also the effectiveness of the BIP. Is this plan, when implemented perfectly, working? And after that, make some changes based on that new information. I will caution you here and say if you see a punishment used in a behavior plan, that's a red flag. What you really want a behavior plan to focus on is reinforcing the behavior you want to see. Also, remember that not everyone finds the same things rewarding.
There is one big exception to the rule that a child is returned to their original placement if one of the MDR standards are met. This generally applies to behaviors that are a danger to other students or staff, such as incidents involving weapons, controlled substances, and serious bodily injury. In these cases, a school can change a child's placement for up to 45 school days, even if MDR standards 1 or 2 are met. Students in these situations still have the same rights for long-term removal, such as continued services and conducting an FBA and creating a BIP.
And the ultimate school removal for the most serious conduct violations, expulsion. The school board will consider the nature and seriousness of the violation, the degree of danger to the community, students' age, discipline history, as well as all the factors the MDR team considered, even if the MDR team found it not to be a manifestation.
When are schools required to give parents notice for disciplinary actions? Well, when students face long-term removal, parents must receive prior written notice of this action no later than 10 days after the discipline action. If you'd like to learn more about prior written notice and what needs to be included in these notices, please see our other materials on our website for eligibility. Parents must also receive a copy of the procedural safeguards, which explain a parent's rights and options if they disagree with the school's decision. Parents must also receive notice of the MDR meeting.
Some new standards went into place for all students recently, or relatively recently, depending on when you're watching this. These standards went into effect July 1st, 2018. It's not just for students with disabilities related to out-of-school discipline. For pre-K through 3rd grade students, they can only be suspended or removed from school for 3 days, and they can't be expelled, unless there's some physical harm or aggravating circumstances like bringing a weapon to school. Then for all students, the number of total days they can be suspended in a year has been reduced from 364, basically an expulsion without being called an expulsion, down to 45 calendar days total. Again, unless there's been some physical harm or aggravating circumstances. Thank you for joining us. We hope you found this information helpful. For more information, please see the resources available on our website. You can also find our contact information online.